Well, a court ruling involving a New Jersey farm could have a substantial impact on how federal agencies enforce ag labor regulations. And while the case involved the Department of Labor and USDA's H-2A program, its precedent could apply to a range of other disputes. Well, Roger McEowen with the Washburn School of Law joins us now for more on this. Roger, always appreciate your time. A little recap on this case. I understand it arose from a dispute over the use of the H-2A visa program for seasonal workers.
Yeah, it did, Suzanne. Good to be with you. This was a farm in New Jersey that hired 19 H-2A workers, and the Department of Labor came in and alleged that the farm had breached its employment agreement with the workers by failing to provide such things as adequate lodging and meals and transportation, and by failing to provide a guaranteed number of work hours. And instead of bringing the case in federal court, of course, what the Department of Labor did was say, well, you got to go through our administrative process. We've made the determination. Now you're going to have to sit before our administrative law judge that's going to make the decision, probably in our favor, and then you got to go all the way through that process before you can get to a court. And the farm said, no, I don't think so. There was a court opinion by the decision by the U.S. Supreme Court in 2024 that they thought, since this was just a contract dispute, they could go straight to court.
So, all right, we're going to talk about the relevance of Article 3 in the Constitution. How does it tie in with this case?
Yeah, this little history lesson for those listening today, because this is really the crux of the farm's argument. They said, look, Article 3 of the Constitution is what establishes the judicial branch of the federal government. And a violation of Article 3 typically occurs when either the legislative branch or the executive branch, the other two branches of government, usurps the power of the judiciary, or when the judiciary itself oversteps its constitutional bounds. So we're talking about separation of powers. And here the court said this was basically a contract matter between the farm and the Federal Department of Labor. And last year they said, like I mentioned, the Supreme Court clarified that these types of matters are for the courts to decide without first going through the administrative appeal process. And so now we have a federal appellate opinion that is following that U.S. Supreme Court precedent.
And the appellate court ruling?
They agreed with the farm, and they said this is a private contract matter. It's not subject to the administrative appeal process, where the agency, as I said, gets to be judge, jury, and executioner. You get to go to court directly.
When we look at a case like this, Roger, the impact that this ruling has maybe for other issues within agriculture and moving forward, really setting a precedent.
Yeah, I think it does. I think it's huge, Suzanne. We think of all of the problems that farmers can get into with disputes concerning FSA rules, NRCS rules. And what the court is saying here, in following what the U.S. Supreme Court said last year, is that if this doesn't involve something such as the federal land on Bureau of Land Management disputes, or some type of other IRS dispute where you've got federal tax dollars involved, if it's just a private contract matter, and a lot of these disputes that farmers have are, you didn't comply with a program rule. That's a private matter, the courts are saying, and that you can bypass the administrative appeal process, and you not only avoid the cost of that, but the data has shown for many years that you have a much greater chance of prevailing on the merits if you can go directly to a judge rather than going through the USDA administrative process. So good news, I think, all around for producers.
Yeah, so important that our farmers know their rights, know the law, and have somebody like Roger McEowen to, of course, source. Roger, always a pleasure. Thank you so much. Roger McEowen with the Washburn School of Law. Very smart man.